collaborated in my job several times with law enforcement and had some successful cases. And I guess what I wanted to start out with talking about was, I was thinking before I did this presentation.
Is that better?
Yeah. Is one of my first contacts with law enforcement, and this was 23 years ago, when I got a sexual abuse case. It was a 19-year-old young woman who had mental retardation, and she was having a sexual relationship with a businessman in the community, and he was trying to teach her how to, quote, be with a man. That was what he was doing, and it was obvious that this woman did not have the ability to consent to this. So I contacted the local police department and asked them if they would cooperate and help me with this case. Well, at that point in time, they weren't interested at all. And they were sort of like, she's not a good witness, she's got mental retardation, But then what they said is, if you want to gather evidence for us, then we might look at that case. So I'm like, we gather evidence? And they said, we want you to go out and collect the bed sheets from this woman's house and bring them to the police department. So I took the trash bag, put on gloves, and put the bed sheets into the trash bag and took it to the police department. Now, who wants to guess that would happen right now? No, I don't think you'd want me gathering the evidence for one thing, and that was asking quite a bit. So we've come a really, really, really long way. I'll just start out by talking about Adult Protective Services, is that we do investigate abuse, neglect, and exploitation reports for 18 years and older, like Paul was saying, who are incapacitated, and 60 years of age if they're incapacitated or not, no matter what, if they're 60 and over, they're clients of ours. And this is our definition of incapacity, specifically for how we decide this. So when somebody calls in and they're under 60, it's sort of up to our intake worker to make a decision on whether they meet the criteria. So it's really subjective about if they meet the criteria, trying to decide if they do have the sufficient understanding or capacity.
Might be easier to just hold it.
Yeah.
You may have to hold it up the line.
All right, is that better?
That's better.
Okay, sorry. So this is a definition that we use specifically for who are incapacitated adults. So let's just start out with somebody's reporting to us. They're calling in with a case. These are the people who were required by Virginia law to report to APS when they suspect abuse, neglect, or exploitation. As you can see, it's quite a few persons who are required to do that. Mental health people, medical personnel, and as you'll see at the very bottom of the list is law enforcement. So law enforcement officers are required to alert us when they suspect abuse, neglect, or exploitation. One of the things that I think is real important for this group to understand is that we are not allowed to disclose the name of the reporter unless we have permission from the reporter. And I'm going to give an example of a recent case with an investigator who happens to be in this room, who's a very competent and very thorough investigator. When he asked me the name of the reporter, I said, I can't share that with you. And he was like, you can't share that with me? And I said, no. And he said, well, I really need that information to help me with the investigation. I really need to know so I have a better idea of where this case is coming from. And I said I couldn't do that. And what happened is we had not initially gotten permission from the reporter on this case. It was a financial exploitation case. And we went back to try to get permission from this person. That person was no longer at the telephone number. So we're not able to share that. So it's not that APS is trying to be difficult or hinder an investigation that law enforcement might be doing. It's just that we cannot. It's very specific to our code that we cannot do that. We have never used this before, but just threw this in just because I think it's kind of interesting that, I know that we probably don't get as many malicious reports as maybe CPS does, but we still do occasionally where we suspect that it might be malicious. Now, law enforcement is required to contact us as a mandated reporter, but we are also required by law to contact law enforcement if these three things, if any of these three things occur. And of course, sexual abuse is the first one. We immediately have to contact them, or as you can see, death or seriously bodily injury or disease that is a result of abuse or neglect. And then any criminal activity that places the adult in imminent danger of death or serious bodily harm. Besides that, we're not required by law to report to law enforcement. When we do coordinate a joint investigation, and this is not just with law enforcement, it might be with Department of Licensing, which would jointly investigate complaints of abuse, neglect, and exploitation in assisted living facilities. So if we were to do that, these are the things that we can share if we're doing a joint investigation. So if I'm doing an investigation with law enforcement, I can give him all of this information. So as you can see, you pretty much can give information except for the reporter. This is probably one of the things that's most helpful to law enforcement. It's helpful for us, but it's helpful if we're doing a joint investigation with law enforcement. And that is that all persons who are mandated reporters are required to disclose information to us that we would need for an investigation. But what's also good is it doesn't even have to be the person who made the report to us. If somebody is a mandated reporter and they have information that would help us, then they're required to give that to us. So an example would be if a neighbor made a complaint on an elderly woman who lived next door who had some suspicious bruises. She lives with her grandson, and the lady's like, I'm not sure what's going on, but I think something's up here. Well, I can contact the doctor and ask him to provide medical reports to me that might provide some information on her physical condition, her mental condition, even though he didn't make the report. And what I've added in here is, this is a form, and I just put this in mainly for APS workers because I don't know if all APS units have this, but this is a form that we can use when we are requesting information, because it basically says, even though HIPAA's, all the laws that are involved, you are required to give information to us. So it's very helpful, and in terms of law enforcement, if we're doing an investigation with law enforcement, then that's really good because then the information that we get, we can share too, and it would help with the investigation. Just for your interest, confidentiality, APS records are confidential, and we are not subjected to the Freedom of Information Act. And also, if we receive criminal investigative reports from law enforcement agencies, then we need to keep those confidential, except where we talk about here. Okay, we've gotten a call, we've gone out to investigate the situation, and we realize that there is a neglect, abuse, or exploitation happening. So the first thing we want to do is stabilize the situation, and we want to prevent any further abuse, and neglect, or exploitation. One of the things, and I think it's interesting because he said something about this right to self-determination, he doesn't, Paul didn't particularly like that, but in Adult Protective Services, that's sort of our main philosophy, is that people do have a right to self-determination, and that people have the right to make mistakes. I mean, they're adults, they have the right to make poor choices and use bad judgment, and who in this room hasn't made a poor choice or used bad judgment? No. So that's the way that we look at people, that they have a right to do that. We also use the less restrictive and less intrusive intervention. A lot of times we'll get calls from somebody and they'll say, my neighbor is elderly, she can't take care of herself, stick her in a nursing home, please. You know, we don't do that. That's pretty intrusive. That's pretty much changing her lifestyle. So what we would do is go in, try to stabilize the situation, give her resources so that the abuse, neglect, or self-neglect is no longer happening as best we can. We don't always have all the answers because we don't sometimes have resources that we really would fully keep somebody in their home, but we try our best to do that. And like I said, they have a right to say if they have capacity and something bad is happening to them and they don't want us to be there, they can tell us to not come there. They can tell us to leave. What I put in here is basically, just for interest, is the types of things that we are allowed to do using judicial proceedings. And most of these are done with our attorney for Adult Protective Services petitioning the court. And you can see here, it's for people who lack capacity to consent, and we feel like some type of a legal intervention needs to be done. First one is, if we get an APS complaint, we get a report, and we try to go in there and somebody tries to stop us, then what we'll do is we'll keep trying to go back. We'll keep trying to make the best contact or try to be as appropriate a person as we can with them. But if they finally just say, you cannot come in here, you cannot, somebody's stopping us, then we would use this code section. If we are, if we are giving services to an adult, and something happens and somebody else tries to stop us, an example I would give would be like a mother whose son who's abusive to her and doesn't really want us involved because he doesn't really want us to find out that he's financially exploiting her or find out what's really going on. He might try to stop us, and so he cannot do that because we would be able to go to court to stop. An emergency order for adult protective services. This one we've used several times. I know that this is a very helpful one. We've had a couple situations where we have really seen a positive result of being able to go to court. Like I said, we try not to go to court unless we absolutely have to. But if a person lacks the capacity to consent, an emergency has to be obvious. We have to have an emergency, the person is unable to consent. Then basically what this does is allows us to become a guardian for that person. And so it's very helpful when you have a situation where you really don't have a lot of resolution to it. And the example I'll give you is, and this is just kind of bizarre when I think back on it because it was a very upsetting thing to have seen. We've seen a lot of stuff, but this was very upsetting. A woman contacted our office because she had concerns about a neighbor of hers because she was pretty sure that the caregiver, which was her husband, was being physically abusive. So she was watching this situation and decided to videotape it. So what she came to us with was a videotape of the husband smacking the elderly person and dragging her through the yard. So that pretty much was fairly serious. Well, of course, we tried to do the least intrusive, so we went to the person to see, did this gentleman need caregiver relief? Did he need something? Could we provide services in the home to make it better? What could we do with that? Well, we talked to him, he was belligerent, he was angry, he was not cooperative, it was really a bad situation, so we went to court with this. Well, how fast do you think it took that judge to give us this order when he saw that video? Like hardly anything. He saw like the first, Paul was, he's our attorney, he saw like the first little bit, he's like, I've seen enough. So it was one of those situations which we were really lucky on. Sadly enough, the only thing that we could really do with that was to place her in a nursing home because she was at risk. This man was so burnt out with caring for her that we did place her in a nursing home. And because we were the guardians, then we were able to check her into the nursing home, complete the paperwork and that type of thing. This allows us to be a guardian for 15 days, and then if we need an extension on that, we can do another 15 days. Now, we did recently do one, too, where we took an emergency order, and some law enforcement might have been involved with this case, local law enforcement, with a woman who was deaf who kept walking down the middle of the road. And police officers kept picking her up, sheriff's deputies pick her up and take her back home again. And so what we did is we wanted to do an emergency order because we felt like this was really serious. She was very much at risk of harm or death. And when we took it in front of the judge really didn't like this case. And he said, no, I'm not going to grant that to you. I'm going to ask you to try to work with this family and try to see what you can do. And ordered him to work with us to see if there was something we could do. Well, we tried an alarm system. Of course, this woman again is deaf. We tried an alarm system with lights and that type of thing. And what happened? It didn't work, and she was back on the road. She, luckily enough, did not get harmed, but she very easily could have. But that was one where the judge really didn't felt like we were taking away too much of that family's rights. So, judicial authorization of treatment is another code section that we can use if we have somebody who needs a specific type of treatment for some type of disorder. And we've done a few of these. If there's nobody who can legally authorize and the person is not able to give consent and does not appear to understand what the needs are of that person. So what we can do then is we petition the court. And I'll give you the example that we had one a few years ago, several years ago, at a nursing home. The nursing home contacted us to say that this gentleman who had mental retardation and mental illness was in need of some type of a kind of an intrusive a surgical procedure because he wasn't breathing very well. He didn't seem to understand he wasn't breathing, but he was really kind of wheezing and gasping, and he didn't seem to care. He was very, very, very leery of doctors and that type of thing. So the magistrate came to the nursing home, and the doctor and myself and staff from the nursing home testified as to what was in this person's best interest and had medical information showing that that person really wasn't able to consent to the proposed treatment that was being requested. And so we were able to get that. And after that, he lived for several years following that. One of the things, and I know everybody in here knows this, and how easily abused a power of attorney is. That is like the number one thing that we see is so easily abused. And so if we get a case that's a financial exploitation and we have a power of attorney that we think has exploited someone, the person, the client, then what we can do is we can request them to give us an accounting of what they've done with the client's funds. Now, there is a list. The code section does give, there are other people who can do this too, some family members, but APS is specifically listed on there. And there's a good chance that family members who are exploiting them are not going to want to have, aren't going to request to have that done. So if we step in, you know, that's something that we can do. And we had a case recently where our attorney wrote a letter to the person who was the exploiter and said, we need this. And then I think his attorney wrote back and ended up getting the information. But this is a code section that we can use, and this is very helpful for law enforcement too, because we can gather the information and then we can share that, and you can make a decision on whether this looks like a good case to be able to take to a Commonwealth's attorney. Most people know what an appointment of guardian is. We do guardianships. Again, we try not to do them too often. I'm sure that's hopefully the way that most protective service units are, but we are able to file a petition to have a guardian appointed. We need somebody to make decisions about their person, and then a conservator if that person needs assistance with their finances. This is the code section that Paul was talking about. And this is probably the most important one that we need to address today, and that is the criminal abuse and neglect of incapacitated persons. And this is what he was talking about. It specifically says incapacity. And we've had a discussion over lunch and looked at the code section because for some reason we were thinking that elderly, that was somewhere in there, but it is only incapacitated persons. Now when we looked up the definition, it says by advanced age that an elderly person is included that. But this is the one that we would really like to see used more often. We need more prosecution because the more.
Well, I was just thinking that at the very first slide, I think it was the very first slide where you defined incapacitated adult included that.
Right, advanced age, yeah.
So you kind of.
Fit that in.
Right.
What was the question?
I don't know if you want to repeat it on the mic so they can hear what having to do with the two.
What I asked her was, in her very first slide, she defined incapacitated person to include an elderly person over 60. So
Oh, advanced age.
bootstrap it right in through the original incapacitated definition.
All right, so what we want to do, what you can see here is that somebody who does not result in serious bodily injury or disease, that is class 1 misdemeanor, and then of course the one where they are guilty of the result of serious bodily injury or disease. And we'd like to see this used more because we think if that's obvious to the public that we're not going to accept neglect or abuse of incapacitated persons, that that's the best thing that we can do. So hopefully this coalition will advocate for and try to teach prosecutors about how important this is. Working with APS, particularly for law enforcement, it's easy for us to establish a relationship with a client because we're comfortable and used to working with this type of clientele, elderly and people with disabilities. And we can help with the interview process, hopefully to make them comfortable, to be able to get as much information as possible. And we can help to obtain information. Like I said, we can get information that maybe law enforcement can't get without, you all might have to subpoena, but this is stuff that we can get and provide to you to help you know if this case is something that needs to be pursuit. Background information, there's a good chance that we have a lot of repeaters, so there's a good chance that we have some type of history with the person, and that would be helpful to have a better understanding of the whole picture. And we can assist with transporting the client, helping the client through the court process. We can pick up the client, take them to court, and sort of be there for them so that they will feel more comfortable, which of course in the end would help with the prosecution. And then also we assist clients with obtaining community resources. And that would be, we have clients, we know what resources are available, things to help the clients, so we can do that. Our goals, and maybe somebody would like to say what they'd like to see goals besides this, since we have a few minutes. But these are the goals that I was just thinking would be important: to strengthen the relationships between adult protective services and law enforcement and Commonwealth's attorneys, and learning what cases are appropriate for referral and what you all would like us to look for when we're investigating complaints, reports, what you would think that would be helpful for your all's cases, and just how we can help each other. Because I think we're getting to be more of a symbiotic relationship. We are really beginning to work together more, at least in this area. And I don't know, I know there's a lot of people from around the state, but I think if we can learn how to help each other, that would be good. Interagency, I went on the internet to sort of just look to see what other places were doing interagency. They have a lot of teams with APS workers and law enforcement. There's some really neat things that are going on now. And then identify barriers to advocate for legislative changes. And that would be, as you saw, mandated reporters. Who is not a mandated reporter for financial exploitation? That would be probably one of our best referrals. Banks would be absolutely wonderful. For years, I think the state has been trying to get that passed, and I'm not sure it's because they have such a strong lobby. I don't know what the reason is, but we really haven't been able to get that passed. We would get there on the front line. They would be able to just identify so many things. Occasionally, we'll get somebody who contacts us from a bank, but they are not mandated to do so. So that would be one legislative change that we think would be real helpful. So if we can identify barriers, basically just learn to communicate together on what you all want and what we want. I put this as my last slide, but of course Paul Greenwood kind of threw that out the window. Because he said that wasn't really true. But historically speaking, that has been a problem, because our clients, what makes our clients the most vulnerable is what makes them the most difficult to prosecute. The ones that are demented, who are so vulnerable to being exploited, are the problems with making them a good witness. And it really is tough. So let's hope that people like Paul can get us to be thinking in a different way. Okay, yes.
Are your services available for a federal prosecution of, say, elder abuse or something?
I assume so. Oh. I assume, yeah. Yeah, or anybody from this, yeah. Where's Margie Mark?
She had to leave.
Oh, okay.
But I would say yes, as long as it's
Sure.
looking at an individual person, that meets our validity criteria. I mean, if you're talking about federal prosecution of a nursing home, that might not be in our jurisdiction. But if you're talking about individuals, yeah.
Yes, ma'am.
Another thing I wanted to throw out there is consider contacting your local long-term care ombudsman. I'm the ombudsman for Charlottesville. I work really closely with this Charlottesville area, and on occasion, discuss things with the Commonwealth attorneys too, as well as the community service board and the hospital. We're limited to some extent in what we reveal about our clients, but we know a lot about the long-term care network, and I think some of it is long-term.
Did everybody hear that? What she was saying is making contact with your long-term care ombudsman, or helping with this. Does anybody have anything else? Derek's up here, so I'm assuming I'm done. Stick a fork in me.
He's got fun.
Yeah, he's not done, right? Anybody else? Okay, thank you.
Question.
With the wording of mandated reporter, the section where it calls for emergency response personnel, the wording physician in the hospital, that they have met their mandated reporting responsibilities. Has that had a significant impact? I think it's been a year now that it's went into effect. Has that had an impact on the mandated reporting reports that they themselves make?
No, I don't think so, no. I still get them, we still get them from medical personnel directly. So no, I don't think it matters.
Are you by chance going to provide your slides online or? Oh,
I see, yeah.
Not everyone
Sorry.
got it.
Yeah, and most of the slides I took directly from the Adult Protective Services Policy Manual. So if you look at the manual,
Oh, I was just
you'll see,
looking at the-
yeah, you'll see the correct.
the regulatory language.
Yeah, yeah.
Any final questions? Okay, we're ahead of schedule. We like to be ahead of schedule, so what I need for you to do now is take a 15-minute break, be back at 25 after.